Felipe Massa can proceed with parts of a £64 million legal claim over the conspiracy he alleges denied him the 2008 F1 title. But while Massa's proven he has a realistic chance of succeeding in court in some areas of his controversial legal action against F1, the FIA, and former F1 Supremo Bernie Ecclestone, other aspects have already been thrown out. Massa argues he is the victim of skullduggery following Renault's Crashgate scandal in the 2008 Singapore Grand Prix, and an alleged subsequent Ecclestone-Max Mosley cover-up to keep the truth under wraps until it was too late for Massa to do anything about it. He had claimed damages and declaratory relief, which meant he wanted an admission he is the rightful 2008 world champion and not Lewis Hamilton. F1, the FIA and Ecclestone say that Massa's claims are misconceived and brought well out of time. So as the defendants, they applied for a UK High Court judge to rule that Massa had no real prospect of success and therefore the case shouldn't go to trial. The mere existence of Massa's pursuit has been a curious and belated development in one of F1's biggest ever controversies. The defendants taking this procedural route to get it struck out early and failing to do so entirely makes the ruling from the Honourable Mr. Justice J a big development. It's important to stress early on that not every aspect of Massa's case or the arguments either way have been fully presented, scrutinised here, or passed judgment on. As the judge stressed, this was not a mini-trial, despite the defendant's submissions that he described as unnecessarily elaborate and complex. An alternative approach could have been pursuing it as a preliminary issue, essentially a small standalone trial with full evidence, witnesses, disclosure, and so on. The defendants presumably wanted to avoid this for the same reasons they don't want it to end up as a complete court case. It's considered unnecessary, you don't know what's going to get out in the public domain, it's expensive and controversial. That left it open for the judge to rule on though, and his verdict, handed down on November the 20th, makes for fascinating review, leaves the door open for Massa's big day in court, and gives some early clues for where the main arguments will be. Without wanting to spend too much time revisiting Singapore 2008, the essential facts here relate to Massa losing crucial points when Renault orchestrated the deliberate crash of Nelson Piquet Jr. to assist teammate Fernando Alonso to victory. When race leader Massa made a pit stop during the safety car period triggered by Piquet's crash, he rejoined with the fuel nozzle still attached and then had to serve a penalty for the unsafe release. Massa finished a pointless 13th, while Hamilton was 3rd, giving Hamilton a 6-point gain in a championship he famously won by a single point. The following year, the Crashgate scandal was exposed, Renault and the perpetrators were punished, but there was no after-the-fact sporting remedy. Massa argues the race should have been annulled or the 2008 points adjusted in another way. This court hearing wasn't about all the specifics of that, let alone the argument that had Singapore simply not happened, the points permutation would have been different at the time and there were still 3 races left to go. Instead, what was heard in court on this occasion related to Massa's various claims: breach of contract against the FIA alone, an act of inducing breach of contract against Formula 1 management and Ecclestone, an act of unlawful means conspiracy against all 3, and a claim brought against the FIA founded on breaches of duty owed under its statutes. These centre on Ecclestone and former FIA President Mosley allegedly covering up the emergence of the crash scandal sooner. Massa's case goes that Nelson Piquet Sr. told then FIA race director Charlie Whiting at the end of 2008 that the Singapore crash was deliberate. Whiting then informed Mosley, and that Whiting and/or Mosley told Ecclestone, but the information was deliberately concealed. It was known back in 2009 and the time of the original FIA World Motorsport Council trial that Piquet had spoken to an FIA official in 2008, which was Whiting. But the short version was the FIA didn't have enough evidence to act on sooner. In 2023, quotes from Ecclestone were published by F1 Insider in which Ecclestone allegedly claimed he and Mosley were both informed during 2008 what happened in Singapore, and then suppressed the information. In the court's own translation of the interview published in German, Ecclestone said he and Mosley decided not to do anything for the time being, wanted to protect the sport and save it from a huge scandal, and that Ecclestone used every last power of persuasion I had with Nelson Piquet Sr. to get him to keep calm, the older Piquet being a champion with the Brabham team that Ecclestone once owned and Whiting worked for. Ecclestone supposedly added that we had enough information in good time to have investigated the matter, and we probably would have had to annul the race in Singapore in those circumstances. You can see why this was of interest to Massa. The judge pointed out that at trial some of these facts would be contested and that Ecclestone doesn't accept this interview is a true and accurate reflection of his state of mind. In other words, the quotes in question from an interview conducted in English then translated into German before being published are being contested in some way. But the judge admitted this interview is the moment we can join up the dots by drawing an irresistible inference that Mosley would have told Ecclestone at the time, something that Massa couldn't have reasonably known before 2023, even if he suspected it. And as we'll explain shortly, this is crucial to one of Massa's claims proceeding to trial. This is a judgment that both sides are heralding as a win. There were 4 grounds from the defence in an attempt to kill the Massa case before trial. 2 of them worked, hence the FIA's triumphant press release on Thursday that it had succeeded in summary judgment application against Massa. We'll start with the declarations first, which is the part where Massa sought acknowledgement that he'd been wronged. It has long been accepted that there is no recourse for Massa to actually be given the title, but he wanted it symbolically in the form of 1. A declaration that the FIA acted in breach of its own regulations in failing to investigate the circumstances of the crash promptly in 2008, and a declaration that if the FIA had not acted in breach of its own regulations, it would have cancelled or adjusted the results of the Singapore Grand Prix, with the consequence that Massa would have won the Drivers' Championship in 2008. His case is that this is the most effective means of doing justice, as they avoid overruling the results but remedy an historic injustice. This was also used to argue against the defendant's objection that this would wrongly interfere with the FIA's exclusive jurisdiction over sporting disputes. But it actually worked against Massa, who the judge described as caught on the horns of a self-imposed dilemma. The judge reached the firm conclusion that declaratory relief would not be granted at trial, as the courts will not entertain cases which serve no sufficient or legitimate legal purpose, which the defence had claimed Massa had failed to prove evidence of. Massa seems to accept that any declaration would not have any legal and practical effect on the FIA because he knows it wouldn't actually change anything in real terms, and he is not entitled to claim declaratory relief just for reputational or publicity reasons. The judge said that rewriting the outcome of the 2008 Drivers' World Championship would be how Massa would present his victory to the world and is how it would be perceived by the public. It would also come too close to impinging on the right of the FIA to govern its own affairs. Other defences related to a breach of contract claim and a claim against the FIA for breach of duty. The judge ruled that the breach of contract claim wouldn't continue to trial, as there was no real prospect of success and a statute of limitations had passed. He also found that duties were not owed by the FIA to Massa personally, only to FIA members. As far as the FIA is concerned, it's a win that any full trial will now only occur on what it calls significantly narrowed grounds, and that the judge expressed serious doubts about the standalone claim against the FIA, which is governed by French law. Massa's been advised to abandon that as well, or obtain further French law expert evidence to support it before getting approval from the judge to pursue that further. Massa called the judgment a tremendous victory and a great day for me, for justice, and for everyone who loves Formula 1. He can still pursue his big money claim, which he says reflects the difference in salary he would have received in subsequent years and the loss of sponsorship and other commercial opportunities. An effort to get the claims thrown out on the grounds of a time limit failed entirely. It was argued that Massa should have acted after the original 2009 WMSC decision, and that Massa's alleged losses were caused by his own failure to appeal to the International Court of Appeal, which the defence admitted broke the chain. This failed as the judge said the defendants needed to prove that Massa would have won that appeal, not just that he might have, and the judge can't reach that conclusion in this forum. In addition, the content of the failed breach of contract claims still supplies the unlawful means part of Massa's conspiracy claim, which is probably the most interesting part of the case, and along with the inducement claim, survives because the judge says Massa has a real prospect of proving the limitation period should be extended. It was felt that what material existed in the public domain at the time did not necessarily put Massa or a reasonable person on notice of a conspiracy to avoid a timely 2008 investigation. But the Ecclestone 2023 interview changed things because of what we said earlier about being able to join the dots. So the judge essentially finds that Massa has a real prospect of proving that there was deliberate concealment. If he wins this at trial, it would mean instead of Massa having a 6-year statute of limitations running from 2009 to take action, the clock only begins from 2023, so it wouldn't have expired. The fact that this case isn't dead means that there are surely going to be more fascinating developments to come. But the judge has noted several potential obstacles to Massa succeeding at trial, including whether the true cause of scoring no points in Singapore and therefore not winning the title was not the Piquet crash but Ferrari's disastrous pit stop, whether there was any real prospect of the case ever coming before the WMSC in 2008, given Piquet remained under contract with Renault at the time, so wouldn't have cooperated the way he did after being fired a year later, whether there was any real prospect of the WMSC reaching a different decision in 2008, much less a decision that would have resulted in Massa winning the championship, as maybe the 2009 decision would have just been reached a few months earlier. That other potential remedies, rather than just null and void the Singapore race, could have been pursued in the interest of fairness to other parties, including Hamilton, and if there was a WMSC decision in 2008 and Massa lost, was there any real prospect of a successful appeal to the ICA? The judge felt the need to stress all of this to point out that this litigation wouldn't necessarily be plain sailing for Massa were this case to go to trial, and he didn't want the impression to be gained that he's oblivious to at least the possible obstacles. In short, there is still no guarantee that Massa will win anything, but he looks like he'll get a chance to try.